Excellencies, ladies and gentlemen, good morning, good afternoon, good evening to all of you, the online audience and those present here at IPI, for this discussion entitled Legal Avenues to Fight Climate Change. It gives me a great sense of satisfaction to be co-hosting this event with the permanent mission of the delegation of Liechtenstein to the UN, and in particular with Ambassador Christian Venevesser, an old friend who, like me, has a long experience in working on legal issues here at the UN. And I'm delighted, therefore, before moving into the main body of the discussion, to invite Ambassador Venevesser to introduce the topic, and we will then move into a panel discussion, and I will introduce the panelists, and we will hear from them. We have two who are with us here, and then two who are online. So, Ambassador Venevesser, Your Excellency, will you please come and introduce this topic?
Thank you so much, Zeid, Mr. President, and welcome to everybody in the room and everybody online. Thank you for joining us for this virtual policy forum on legal avenues to fight climate change. A very warm thanks to you, Zeid, and to your team here at IPI for organizing this policy forum, which is intended to be the first in first round of discussions on legal approaches on the discussion to tackle this important issue. The climate crisis is clearly the defining challenge of our time. From weather extremes to sea level rise, all regions of the world are affected by the devastating consequences of climate change. In the words of SG Antonio Guterres, we are in the fight of our lives. The 2030 Agenda on Sustainable Development, of course, does provide a blueprint for the prosperity of our planet and recognizes the interlinkages with other big challenges of our time, be it hunger, be it poverty, or the others laid down in the 17 SDGs. And of course, we are meeting today not that soon after the conclusion of COP26 in Glasgow, probably the most anticipated international gathering this year that promised to build on the Paris Agreement. And indeed, countries did agree on the details for the practical implementation thereof, reaffirmed the need to limit the temperature increase to 1.5 degrees Celsius, and also on a phase down of coal power and the phase out of inefficient fossil fuel subsidies. The COP26 meeting did meet with mixed reviews. It is fair to say, among policymakers, among civil society, and among others. I think it is fair to say that everybody does agree that much more needs to be done if we are to stay within the 1.5 degrees Celsius limit. Those disappointed in the outcome of COP26, and it was very striking to me when I listened to the commentary thereafter, emphasized very strongly that they will resort to legal action to get the results that they believe are required in the area of climate action. And this is something that we wanted to have a discussion on today. We're meeting, of course, also at a very opportune moment, because earlier this week, the Security Council had before it a resolution on climate change. It would have been the first thematic resolution before or adopted by the Council that would have defined clearly climate change as a threat to international peace and security. It did find unprecedented support in the membership, with 113 co-sponsors. Nevertheless, it was unfortunately not passed, something that we found extremely disappointing, being one of the co-sponsors, and honestly, in our view, also very problematic for the relevance of the Security Council. Nevertheless, it shows that that more is needed, and clearly, those behind the resolution have indicated that they will certainly continue the fight. The meeting today aims at giving an overview of the legal approaches underway to fighting climate change at the international, regional, and national levels. It will present the initiatives on the way, put forward by those who have been a part of those initiatives. On each of those, more in-depth discussion will be required, and IPI and ourselves are committed to taking this up in separate meetings next year. So we will hear about the call for an advisory opinion on climate change by the International Court of Justice, proceedings at the International Tribunal for the Law of the Sea, considerations of a possible crime of ecocide for criminal proceedings, be it before the International Criminal Court or also in national judiciaries, as well as about the work of the International Law Commission on the topic of sea level rise and climate change. So again, many thanks to you, Zeid, to your team, and special thanks also to those who will be with us to present their initiatives, and I very much look forward to our discussion. Thank you.
Thank you, Ambassador Venevosa, Christian, for the introduction. It gives me great pleasure now to introduce our panelists, beginning with my left, extreme left. I warmly welcome Ambassador Odo Tebi, the permanent representative of Vanuatu to the UN. And as all of you know, Vanuatu is at the core of so many of these initiatives, and we're absolutely delighted and feel privileged that you're joining us, Ambassador. We also have, to my immediate left, is the chair of UN practice at Foley Hogue, Christina, and you'll have to tell me how to pronounce your last name. Huraeus. Sorry, I'm so sorry. No Huraeus. And on our screens, we have Patricia Galvao-Teles, a member of the ILC. Patricia, welcome to our discussion this morning. We're delighted to see you. And we should also have Kate McIntosh, my friend from UCLA. Kate, it's great to see you, and we know that you've been very involved in the crime of ecocide. So with that basic introduction, I'd ask all of you to speak for a few minutes on how you see these legal initiatives and where they fit and why it is that you're involved with them. And then we'll embark on a discussion on separate issues that fall within that remit. Your Excellency, can I begin with you, Ambassador? And you have the floor.
Thank you. Thank you. Well, let me first take this opportunity to thank you, to thank the permanent mission of Liechtenstein. The ambassador is here, and also the International Peace Institute. The president is here for the invitation. Well, as you know, the recent IPCC report, the sixth assessment report, states that changes observed in the climate are unprecedented in thousands of years, and some of the changes already are set in motion, such as the continued sea level rise, irreversible over hundreds to thousands of years. And current assessment of emissions trajectories put the world on track for at least 2.7 degrees Celsius of warming by 2100, a scenario that promises environmental devastation for many countries around the world. Now, we all know what will be the impact of these 2.7 degrees. You know, the sea level rise will continue to rise. The sea will continue to rise. There will be more natural disasters in my country. We have category 5 cyclones every 5 years, and now they are more frequent, and we're losing about 10 to 60% of our GDP almost every 5 years. And in between about 10% of GDP. So this is one of our challenges. Now, so recently at the COP, like our speakers before us have mentioned, the COP, there were mixed reviews, and we need to really think about the future of present and future generations. So we have to really think about their future. I think this is an important area where we have to look at, because we are currently living at a time where we have to show leadership about the future of our generations, as well as us who are still living. Now, Vanuatu is planning to take this issue to the International Court of Justice, but before doing that, we have to go through the General Assembly, because that's the general mechanism or the process that we have to take. And it is not going to be easy. It is going to be very challenging, given that we need the majority of the General Assembly to decide and to endorse it. Now, the question is, are we doing enough to protect the current and future generations? I think that's one of the questions. Well, as the threat of climate change becomes ever more evident, it is critical that states step up their actions to protect present and future generations. However, the glacial pace at which global climate action is progressing shows that states are failing to meet their duties and obligations to protect the rights of current and future generations. This is partly because many of these duties and responsibilities have remained vague and unclarified under international law. This lack of clarity is impeding the ability of the international community to respond effectively to the climate crisis. So what is the role of the ICJ in this case? Well, the International Court of Justice is the highest international court in the world. I mean, the name says it all. As the principal judicial organ of the UN, the ICJ not only settles the legal disputes between states, it also offers advisory opinions on legal questions submitted by the UN General Assembly and other UN agencies and specialized agencies. Advisory opinions may carry great legal weight and moral authority and contribute to the clarification and development of international law for all states. So it's all about the development of international law as well. Now, advisory opinions on climate change would also clarify and develop the international legal principles related to climate change and advance valuable benchmarks. In well-identified and transparent terms, it would set out the relevant duties of states to protect present and future generations from climate-induced harms. An objective declaration of states' obligation of this nature would constitute an independent, authoritative assessment of the adequacy of actual and pledged collective climate action to date. It would recognize that climate change is disproportionately felt by persons in vulnerable situations. Now, the clarification of international law relating to climate change would accelerate state action towards effective and equitable solutions to climate change and assist in determining who bears the responsibility of climate change and the steps taken to address. Therefore, it would enable states to share the burdens and benefits of climate change and resolution equitably and fairly and equally safeguard the rights of the most vulnerable. Fundamentally, all campaigners for climate change would agree that those who have contributed most to the problems have the greatest responsibility to help resolve them. So where does the human rights comes in the legal opinion? That's one of the questions that we may also ask. The advisory opinion can help bring clarity to many of the states' obligations under international law in addressing climate change by integrating human rights considerations with climate responsibilities. It would clarify and align with a consensus expressed in the Paris Agreement that states, and I quote, should, when taking action to address climate change, respect, promote, and consider the respective obligations on human rights, end quote. Doing so would put the nexus between climate change and human rights on firm international law footing, ensuring that states responsible to climate change consider appropriate bodies of law, including international human rights law. This would provide a benchmark for achieving climate justice. Finally, the clarification of international law on climate change would support the achievement of climate justice in the domestic setting through adjudications in national and regional courts. I won't expand on that, but basically let me conclude by saying that the climate justice links human rights and developments to achieve human-centered approach, safeguarding the rights of the most vulnerable and sharing the burdens and benefits of climate change and the resolution equitably and fairly. This is precisely what an ICJ advisory opinion would seek to achieve by clarifying and developing international law. And again, I would like to state that I think posing the right questions will be very important before the court. So I'm sure some of you may be asking what are the questions, but all I would say is, I mean, the right questions before the court will be very important. Thank you, Chair.
Thank you, Excellency, for that overview. Christina, you have the floor.
Thank you very much to the International Peace Institute for hosting this very important event together with the permanent mission of the Principality of Liechtenstein to the United Nations on potential litigation strategies for addressing climate change. As has been widely recognized, climate change litigation has primarily developed before national and regional courts and tribunals, and this approach has had many benefits to date. It's enabled principles to be tested in relatively lower risk environments, with each principle building on the next. And it's also created judicial cross-fertilization between domestic and regional courts and tribunals. Additionally, this incremental approach has also enabled states to pursue legal/political avenues before UN bodies, including the COP26, the open sessions of the Security Council on climate change, peace, and security, and the ILC process on sea level rise, statehood, and migration, about which we'll hear shortly from Patricia Tellis. And these state control processes have given states that are most at risk the opportunity to influence the process, to influence the codification and progressive development of international law. So there are real benefits to the political processes as well as the domestic and regional litigation approaches. That said, we've seen a recent uptick in interest from states in obtaining input from international courts and tribunals on the issue of climate change. And this interest follows on the heels of the 6th assessment report of the IPCC, which we heard about this morning, of last August, which consolidated scientific evidence on climate change and confirmed on a scientific basis what the most affected states had already been warning, which is that the impacts of climate change pose an existential threat to humankind. And indeed, in connection with this report, Secretary General Guterres stated that the alarm bells are deafening and the evidence is irrefutable, and called for a code red for humanity. So it's in this context that we're discussing the possibility of international litigation in connection with climate change. An international climate change case would enable an international judicial system to provide guidance on how best to protect humankind from this existential threat. And the International Tribunal for the Law of the Sea, as a specialized court for the protection of oceans, is well suited to provide such guidance. So now that we've spoken a little bit about the political and legal processes to date, I thought we could speak a little bit about what the objectives would be in pursuing an advisory opinion, be it from ITLAS or from the ICJ. So although advisory opinions, as distinguished from contentious judgments, are not binding as such, their findings carry a certain legal and moral weight. And advisory opinions, they can also contribute to the clarification and development of international law, which would in turn strengthen peaceful relations between states. An advisory opinion from ITLAS could clarify emitting states' legal responsibility to adversely affected states, could also opine on issues such as the concept of transboundary harm and whether transboundary harm can exist, can be found in a situation where two states do not actually share a common boundary. And this combined with a multilateral political approach before the UN and through close engagement with civil society could help advance the interests of low-lying island states and coastal states in pressing other states to limit their emissions. Once rendered, the affected states could continue discussions with other states to address the harm suffered based on the legal principles enunciated by that advisory opinion. And the requesting organ, agency, or organization would be free to decide as it sees fit what effect to give to any such opinion. Additionally, the guidance provided by ITLAS could also pave the way for future litigation or arbitration. Indeed, we saw in the maritime delimitation case, Mauritius Maldives, in upholding jurisdiction, the special chamber actually referred to the advisory opinion of the International Court of Justice of 25 February 2019 on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. And the special chamber found, and I quote, "The determinations made by the ICJ with respect to the issues of the decolonization of Mauritius in the Chagos advisory opinion have legal effect and clear implications for the legal status of the Chagos Archipelago, and that the United Kingdom's continued claim to sovereignty over the Chagos Archipelago is contrary to those determinations." The special chamber also found that while the process of decolonization has yet to be completed, Mauritius's sovereignty over the Chagos can be inferred from the ICJ's determination. So what we see from this decision of the ITLAS special chamber is that an ICJ advisory opinion has both moral and legal effect. And this is what we talked about on the idea of cross-fertilization. One case and certain principles build upon the next. So there are benefits to a multi-pronged approach. So now that we've spoken about the potential benefits to seeking an advisory opinion, I'd like to now address why ITLAS could be a possible forum for such a question or questions. So first, oceans are critical to the climate system. More than half of the increase in global average surface temperature from 1951 to 2010 was caused by anthropogenic increase in greenhouse gas concentrations. And that's reflected in the IPCC's 5th assessment report. And that report found that the ocean has absorbed some 30% of the emitted anthropogenic carbon dioxide since the beginning of the industrial era. So that's resulted in a 26% increase in ocean acidity. So oceans are critical to the question of climate change. And second, ITLAS has a specific mandate to apply UNCLOS, which is also known as the Constitution of the Oceans, and has a specific part dedicated to the protection and preservation of the marine environments. So ITLAS has a special interest and sensitivity towards the issue. And so it should come at no surprise that on the 20th anniversary of the tribunal, one of the presentations was delivered by Professor Yukari Takamura on climate change and the law of the sea, a new role for the tribunal. So this indicates that the tribunal is committed and interested in playing a role on this issue. Now that we've spoken about the status of litigation and political approaches to date, possible benefits to an advisory opinion, and why ITLAS could be a potential forum, I'd like to now outline how that process, the process of requesting an advisory opinion, would work. So Article 138 of ITLAS rules provides that ITLAS can give an advisory opinion on the legal question if an international agreement related to the purposes of UNCLOS specifically provides for the submission to ITLAS of a request for such an opinion. So what you need is a international agreement that relates to the purposes of UNCLOS and that gives that body the authority to refer a question, to seek a question from ITLAS. So ITLAS has exercised this authority under Article 138 before. It did so in a request for an advisory opinion submitted by the Sub-Regional Fisheries Commission. And in that case, the relevant convention included 7 states: Guinea, Cabo Verde, the Gambia, Guinea-Bissau, Mauritania, Senegal, and Sierra Leone. And Article 33 of that convention provided that the Conference of Ministers of the Sub-Regional Fisheries Commission could authorize the permanent secretary of the commission to request an advisory opinion from ITLAS. So in light of this precedent, a valid request for an advisory opinion from ITLAS could be made by an international body composed of several states operating under a charter that relates to the purposes of UNCLOS and that allows for such a referral. So consistent with that charter, depending on the voting structure, be it consensus or majority, that group of states would then decide on whether they wanted to refer a question to ITLAS, and if so, what question or questions. And once that vote or consensus was reached, the secretariat of that body would then refer the question to ITLAS. And thus this process, of course, differs from that of the ICJ. Of course, we heard this morning from Ambassador Tevi that to obtain an advisory opinion, a resolution is required from a UN body, such as the General Assembly. And that, depending on the issue, it could be a significant hurdle to referring a question. In contrast, the ITLAS approach only requires a referral from an organization with the competence to refer the question for an advisory opinion. It doesn't require the approval of a UN body. As we also heard, and I very much agree with Ambassador Tevi, that the request must pose a legal question, and the drafting of those questions should be approached with great care to enable ITLAS or the ICJ to provide an advisory opinion that would be most helpful to the states that are advancing those questions. And an improperly formulated question could actually risk an unhelpful result and could be counterproductive. And so the precise formulation of the questions requires careful consideration. And while a small group of states might want to take the lead with a particular initiative, it's important that affected states and interested parties be involved in the process to ensure that the best possible question or questions are formulated. So with that, I'll close. And again, thank you very much for your interest, for the invitation, and for all of the participants here today.
Thank you, Christina. We now turn over to, are we having Kate first or Patricia? I see Kate on the screen. Let's then begin with you, Kate. If you could make your opening remarks, and then we'll ask Patricia.
Yes, absolutely delighted to. And again, thank you so much for inviting me. Lovely to see you again. And other friends. Hello, Christian, Excellency. And yeah, I wish I was there with you. Very, very happy to be in conversation with such an esteemed group of people. So in 10 minutes, I think, let me talk to you about the efforts I'm involved in to propose a new crime of ecocide as an additional crime to be adopted into the Rome Statute of the International Criminal Court. So maybe first of all, why international criminal law? Well, I certainly wouldn't suggest that international criminal law is a silver bullet here. And I think it was a brilliant idea to have this overview conversation where we look at all the different ways in which legal avenues can be used to try and address this urgent crisis. But international criminal law does have a particular role to play, I think. And one of the most important aspects, I believe, is its expressive value. So I think we should not underestimate the symbolic significance of our International Criminal Court and the members of that court agreeing that destruction of our environment is a crime on a par with the other crimes on the International Criminal Court statute: genocide, war crimes, crimes against humanity, and of course the crime of aggression. I think the impact of that could be really quite significant in terms of shifting the narrative, shifting our understanding, and placing clearly beyond the pale certain acts of massive destruction of the environment. I mean, there are other practical aspects which could be advantageous as well, actually, many around issues of jurisdiction. We might think about universal jurisdiction that might come with incorporation of the crime into the Rome Statute, and also perhaps some interesting questions about where the crime has occurred, which could open up some avenues for accountability, which might be foreclosed at the moment. I think criminal law in general is important for this expressive value, for the value it holds of agreeing that certain acts are beyond the pale, but also because it takes the burden of accountability, seeking accountability, trying to prevent, in this case, the environmental destruction away from the victims. And I think that's particularly relevant in this kind of situation because we know that the victims of environmental damage are often, the people who suffer the most are often people with the least resources and least well placed to pursue the sorts of fantastic creative legal actions in civil cases around the world that we're seeing going on at the moment. And then finally, perhaps, I think the idea, again, back to the expressive value, but the idea of massive damage to the environment being stigmatized in the way that it would be if ecocide was recognized as an international crime could be really quite significant in terms of its impact on corporate decision making, in that even the threat of being potentially indicted for an international crime, I would imagine, would play quite a significant role in decision making in a corporate boardroom. I mean, it's not a good look to be indicted for ecocide. I can imagine it wouldn't be great for the share price. And if I was an in-house counsel, I would be, I think, pretty sure to advise industry to steer clear of anything that might potentially be classified as ecocide. So that's ways in which I think this international crime can complement the range of other really interesting legal avenues that are being discussed today. So jumping quickly into the process that I'm part of, I was part of a panel of 12 people who were asked to come up with a new definition of a crime of ecocide for proposal as an amendment to the Rome Statute. The panel was chaired by Philippe Sands and Dior Falsao of Senegal. There were 12 of us from around the world. The really interesting thing, I think one of the great assets of that panel was it included not only international criminal lawyers, and I would put myself in that category, but international environmental lawyers, climate lawyers. So it was a longer conversation than it might have been, a more complicated conversation than if we'd all come from the same discipline. But I think it was a much more robust conversation. I think we've come out with a better product. We issued the definition in June of this year, and our goal was really to come up with a credible definition that was written in the language of international criminal law, which is, of course, relatively recently developed discipline, which would be credible enough, plausible enough to start a serious conversation about this amendment. I don't think any of us think that it's likely to be the language which would end up in the statute, though I think all of us would be very happy if it was, because we did come up with a consensus definition. But of course, that will be for states to discuss within the context of the Assembly of States Parties. But I do think it was important to have this conversation be taken seriously, that we could come up with a definition which reflected the established practice of international criminal law and also was able to be open to the global regulation of the environment under other international law frameworks, which I'll mention briefly in a moment. So turning to the content of the crime, we went for a short definition, one paragraph definition inspired actually by the International Law Commission's definition back in 1991, when they drew up a draft international crime, a standalone crime that would have been a crime in either times of conflict or in peace, as part of their work on the draft code of crimes against the peace and security of mankind. And that proposal obviously did not survive, other than the extent to which it was folded into the war crimes prohibition, where it of course does now appear in the Rome Statute. So we had one short paragraph, which I'll read out. For the purpose of this statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So it's a bit of a mouthful. I mean, it's hard to grasp because it's very dense without seeing it written down. So I thought I would just pull out a few of the key points. First of all, I'd say that we drew as far as possible in the drafting process on existing international law, and in particular, international criminal law concepts. The points I would draw out for attention, perhaps, first of all, it's a crime of endangerment. So the criminalized behavior is risky behavior, is creating this substantial likelihood of the severe and either widespread or long-term damage being caused. And that, I think, was very important, specifically in a crime of environmental destruction, for a number of reasons. One is that we don't have to wait, or the prosecutor would not have to wait for the damage to manifest. And of course, that damage may manifest over quite a significant period of time. The second is the standard that has to be met would be to prove that there is a substantial likelihood of damage being caused by the acts, and not a 100% causal link between the acts and the damage. And we felt that that better reflected, and we were advised that that better reflected the state of scientific knowledge around environmental damage, in that assessing the likelihood of severe damage was possible, whereas in many cases, proving a direct, 100% watertight causal link would have been too high a standard and might have rendered the crime actually unusable. So we criminalize risky behavior, the creation of a substantial risk. And of course, there are other crimes in the statute, which are crimes of endangerment, particularly war crimes. There are then two thresholds. Environmental damage, of course, to become an international crime has to be, of a very significant level. The first, which is perhaps the simplest to describe, is that there has to be a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by the acts. So we took severe, widespread, and long-term. In the current crime in the Rome Statute, Article 8.2b4, the war crime of causing damage to the environment, these three terms also appear, but in the conjunctive. So it's widespread, long-term, and severe. However, there's also another international law instrument, the NMOD Convention, the Convention outlawing hostile modification of the environment, which uses these three terms in the disjunctive. So there was quite a lot of discussion about what we thought, how we should put those together. And our solution in the end was somewhat of a compromise between the two. We all agreed that damage would have to be severe in order to reach the level of an international crime. And we felt after long discussion that to require it to be both widespread and long-term would exclude situations which we all felt should be captured. And we could think about, very serious damage, elimination of species, etc., or something which could not really be called widespread, but we felt was both severe and long-term. Or on the other hand, something one might think of very serious pollution, which probably could be redressed with the, with serious resources being expended, and so might not qualify as long-term, and yet would be both severe, widespread, and absolutely what we would want to outlaw. So that was our solution for that. Point to note, human harm is not required to meet the threshold of severe and either widespread or long-term. So while in our, and we have a second paragraph which provides some definitions of the terms, while human harm can be taken into account to meet any of those thresholds, it's not absolutely required. And I think that's very important. So the prosecutor would not be required to prove that human harm had resulted. the harm to humans is almost assumed in the idea of ecocide. And I think what we have tried to do, and I think we've succeeded to do, is to suggest that both human life and the environment are both mutually dependent and have value in themselves. So the second threshold, and I won't talk for much longer, the second threshold is that the acts should be either unlawful or wanton. I think unlawful is clear, although not entirely clear whether it's only at an international level or at a national level. And we did that deliberately because of the way international environmental law works and the fact that most prohibitions are made by states at national level rather than in international environmental treaties. But the second term, wanton, is perhaps more tricky. So we had to find a standard, we felt, which would work if the conduct that we're trying to criminalize was not currently prohibited, therefore was not currently unlawful. And clearly that's a situation which we are going to come up against. And we had to look to existing legal principles to do that, of course. What we tried to do was to be inspired by the concept of sustainable development, so the core international environmental law principle, and then to translate that into language which is more familiar to international criminal law. So unlawful or wanton is a term which appears in war crimes. It's drawn from international humanitarian law. But wanton, which we define for ourselves, in the term of wanton, we tried to capture the basic approach, which was that ecocide should be taken to mean damage, extreme damage, severe and other widespread or long-term damage, but that was in no way justified, that was reckless, that was wasteful, that could not be justified. We realized that the whole edifice of international environmental law is built on the idea that we use the planet, we use our environment, but we have to do it in a sustainable way. And some of our using the environment could be characterized as damaging the environment. We thought it was really important that this crime of ecocide be able to speak to the edifice of international environmental law, principles of sustainable development, the Paris Agreement. We couldn't be outlawing as an international crime activity that would be permissible under international environmental law if all of the important principles of international environmental law, precautionary principle, consultation, and the idea of sustainable development had been fully complied with. So in our view, what we've done is incorporate this idea that the criminal destruction of the environment on an international level is that severe and either widespread or long-term harm, which cannot be justified for any social or economic reason, but has gone beyond the principle of sustainable development. Very briefly, where are we now? I think we're at a very early stage. We've had states, as you will certainly be aware, we've had states speak in favor of considering this amendment, of exploring the amendment further at the Assembly of States Parties just last week and also last year in 2019. And of course, I look towards His Excellency from Vanuatu, who have been such a wonderful spokespeople on this point. I think what's happening today is exactly right. This needs to be discussed. I think it's being discussed in academic circles. It needs to be discussed in political and diplomatic circles. And we're hopeful that the urgency of the moment, which Ambassador Veneveta referred to so strikingly at the beginning, this code red will give us the momentum to take the leap that would be required to think about criminalizing at an international level extreme harm to the environment. So thank you very much.
Thank you, Kate. And last but not least, we turn to Patricia. Sea level rise is on the program of work for the ILC. Patricia, please tell us about it. You have the floor.
Thank you very much, Prince Zeid. And let me start by thanking IPI and you, and also Ambassador Venevisa and the Liechtenstein mission for the invitation to be present today. It's a great pleasure to share the panel with such distinguished speakers. And I also wish I would have been in New York, but I'm speaking to you today from Lisbon, Portugal. I'm speaking also, of course, on a personal capacity, since I am not the only co-chair of the study group that has been created by the International Law Commission to deal with the issue of sea level rise in relation to international law. And of course, everything that I say is a personal reflection about the experience that we've had so far in putting this topic on the agenda of the Commission, what is expected to happen, and in a way how this is complementary to the different initiatives that have been already discussed, and how I think this is the key point and the common element to all of them, how international law can be at the service of the fight against climate change, because all these initiatives have in common the fact that international law is being used and developed also as a tool to allow for adaptation to climate change. Of course, sea level rise is only one of the adverse impacts of climate change, and the other initiatives are broader in that sense. But from the point of view of the International Law Commission, not only there was very strong support and a strong message since probably 2015, 16, 17 for putting this topic on the agenda of the Commission, but it's also from our point of view, and it's something that was mentioned in the syllabus when we first made the proposal to include the topic on the agenda. It's that aspect, that adverse impact of climate change that may put in jeopardy all the three elements of the state, the population, the territory, and government. So it's specific in that sense if we think about the other adverse impacts of climate change. So we have started working on this topic with, I think, and again, I stress that, strong message from member states in formal and informal discussions in the 6th committee. And a group of members were included, but also other colleagues, as I mentioned, that then became also co-chairs of the study group. We made a proposal for the inclusion of this topic, and this was discussed in 2018 in the Commission, and the Commission took the decision to put immediately the topic on the long-term program of work, and then also in a very quick manner moved it to the active agenda of the Commission. And I think this is due, one, by the recognition that this is an important issue for member states in the UN, and that there was a strong view that this could be an adequate topic for the International Law Commission to deal with. Second, because there was also a very interesting initiative also by one member state, the Federated States of State of Micronesia, that also made a formal proposal, which is very unique. I mean, all the other topics that are normally on the agenda of the Commission, they are proposals from within, from the Commission. I mean, there are some rare exceptions, one of them being the International Criminal Court, where the Commission drafted the statute for the International Criminal Court, the initial draft, based on a proposal by the General Assembly, and a couple of other items, including in the topic of protection of the environment in relation to armed conflict, where there was also a request from UNEP. But otherwise, the Commission tends to draw up topics that are proposals for members, and perhaps sometimes not be so attentive to the message it's getting, or sometimes the message is not there from member states. But in this case, there was a clear message confirmed by the fact that Micronesia also made a formal proposal, and also because we have in the past already assumed that one of the criteria for choosing topics for the International Law Commission is not just the traditional topics that we know the Commission has worked on law of treaties, state responsibility, diplomatic and consular relations, but also topics that are that reflect pressing concerns of the international community. And certainly the issue of sea level rise and its legal consequences reflects a pressing concern of the international community, and the Commission did decide also because of that reason to put the topic on the agenda. Of course, when we speak about these issues of pressing concern, it is normally the case that state practice is not as developed as in the traditional topics. And this is why I think this is probably the main reason why the Commission, when the topic was included in the agenda, also decided to include it as not as the traditional special rapporteur to present draft articles process as in other cases, but here a study group was formed with a mandate to map the legal issues. So what we're doing is really a mapping of the legal issues, and then to present a study with that mapping exercise and with some conclusions and some recommendations. And then also we decided to limit the scope of the topic to 3 main areas. The area of law of the sea, the area of statehood, the question of the possible loss of statehood and the legal implications, and also the issues related to the protection of persons affected by sea level rise. These 3 areas were areas where the International Law Association had also worked on it and is still working. And I'm also a member, together also with Christina, a member of the International Law Association Committee on Sea Level Rise. So there is already some work that is very interesting and very useful for the purposes of the work in the Commission. When I say that the scope is limited to these 3 areas, it's also important to note that although there were some discussions and although it was included also in Micronesia's proposal, and it might be relevant to some of the initiatives that have already been discussed today, the Commission in the mandate that was given to the study group left on purpose, also because of its sensitivity politically, but also legal difficulty, issues of attribution, responsibility, liability. So this is not something that we are working on, or at least not at the moment, because we don't have the mandate for that. So what has happened since 2018, 2019? We have started with first the law of the sea aspects, and there's been a first issues paper that came out in 2020. Unfortunately, due to the pandemic, the Commission did not meet in 2020. So it was this last spring and summer of 2021 that we had an initial discussion on the law of the sea issues. And there's, of course, an important discussion about whether the baselines and the maritime outer maritime zones and maritime delimitations should be affected or not by sea level rise. And I think there's general agreement that this is something that UNCLOS did not foresee at the time it was negotiated. And some states are already taking measures in order to deposit their charts at the Secretary General's office with the current situation and with the declaration that regardless of this phenomenon of sea level rise, they should not be changed. And so this is an option that the Commission is certainly discussing and evaluating. We've had a very robust and detailed discussion on the law of the sea aspects, and this is to be continued. The work is not yet finished. Those are complex and important questions that still need to be discussed. There was a reaction by member states in the 6th committee, and so we'll go back to the topic of law of the sea. And then next year, we will present a second issues paper dealing with the issue of statehood and with the issue of protection of persons affected by sea level rise, again with the preliminary mapping of the issues that are raised by this phenomenon legally in these 2 areas. And again, we will have a discussion within the study group, and then the outcome of that discussion will be included in the report of the Commission. And then again, we will have the interaction with the 6th committee. And when we do this initial rounds in each topic, we will try to assemble in a single report the outcome of this discussion. So I think the main goal of this exercise is to put on paper an objective mapping of the legal issues and possible solutions. It's certainly not going to be the end of the process, because some of the issues might have to be taken up in other forums. We don't have yet a complete overview of what the outcome will be and what the next steps will be. But we hope that the work that the Commission is doing, and I think it is already generating not only a lot of interest, but also some movement on the part of states that become more aware and that think that certain decisions and certain actions and certain practices must be put into place. And this is because of what was said initially also by Christian. I think there's really a window of opportunity here in terms of time, and that's why it's so important to discuss all these issues. If we were to take the traditional approach of the International Law Commission of waiting for a body of law to develop for after doing the codification of it, in the case of climate change and in particular sea level rise, it could have been too late, or it would be too late. So I think this is an opportunity, and all these different initiatives are in a way a contribution to an international law that is more proactive than reactive, as we know from traditional international law. So I would stop my intervention here, and I look forward to the discussion. Thank you very much.
Thank you very much, Patricia, and my thanks to all the panelists who opined on these issues. At COP26, I was fortunate enough, at the invitation of the delegation of the Maldives, to represent the Maldives in the loss and damage discussions. To say that they were tough is is to say it with a healthy dose of understatement. You've all spoken with a great deal of diplomatic and legal polish, to the extent that the terms used when describing the seeking of an advisory opinion, either from the ICJ or ITLOS, is that we are looking to build, to develop a greater clarification where the law exists, to build a body of legal opinion, to do the mapping in the context of the ILC and identify the relevant aspects, and to sort of begin to probe the issue of definition when it comes to the Rome Statute of the International Criminal Court. We're just at the starting point here. Is there not, the two-part question I have for all of you, is there not a danger that others won't see it simply as a technical exercise, that essentially this is upping the ante? Maybe that is the intention, and there is a design behind this. But if that is the case, then is there coordination between the different initiatives, such that if there is a setback on any one front, that everyone who's working on the other sets of initiatives is well apprised of what is happening? And maybe, Patricia, it's difficult for you to speak about this in the context of you being a member of the ILC, but perhaps Ambassador Tevi, Christina and Kate, you could help us better understand the extent to which there's coordination and a discussion on potential repercussions in the event of setbacks. Ambassador, would you want to go first?
Well, thank you. Well, in terms of the setbacks, I mean, currently we are not talking to other groups yet, so we are starting. But I think it's very important to have a coordinated approach with other groupings and other states. I think this is very important, because a setback will derail most of what we're trying to do. So I think what's important is for us to work with the initiatives taken up by Antigua and Barbuda and Tuvalu. So we need to work with them as well. So I think the collaborative approach would make sense. Though we will be taking a different path, but but also we would also seek their support in terms of helping us with our resolution. I think that it will be very important to work together.
Yeah. Thank you, Ambassador. Christina?
Yeah, with respect to the first part of your question, yes, there are technical aspects of each of the initiatives, but at the same time, I believe that they are intended to take the discussion forward, to apply pressure so that action is taken. So I think there is a dual purpose, at least behind some of the state's motivations in getting involved in this initiative. But a coordinated approach is very important. So, for example, Patricia mentioned that she and I serve on the ILA committee. I'm involved in certain legal initiatives and with different states, and Patricia serves on the ILC. So this overlap of including individuals, lawyers, experts in on various initiatives is important and helpful also for this cross-fertilization of ideas. And likewise, with the different advisory opinion approaches or ecocide approach, it is important to be coordinated. And so convening a meeting, periodic meeting of experts involved in each of these initiatives and states involved in each of these initiatives so that they're communicating, sharing ideas, and ensuring that one initiative is not going to backfire on the other. I think that's a really important approach to take.
Christina, if I could follow up with the permission of Kate and Patricia. If there is a sort of intention or part intention to apply pressure, let's say for the sake of argument, we reach Sharm el-Sheikh or well before that, and those countries who are taking a more conservative approach to these issues decide to trade, decide to begin to work. Will these initiatives then be downgraded, downscaled, withdrawn, if that is a possibility? Or are they now they're on their own rails and they're moving irrespective?
Well, I think it's too early to tell, but as we've noted, there are a select group of states that are sort of leading the charge. And so coordination is important, but that doesn't mean that it needs to be a large group of states that are the ones initiating the process, as long as the most affected states are consulted and have a say and provide input. It can make sense for a select group of states to lead the charge.
Yeah. Would you agree, Kate and Patricia, that it makes sense, a select group lead and there's a sort of loose coalition behind them? Kate?
Yeah, I was going to say, I think I'm looking on the screen now at two people who I think are probably two of the best placed to think about how to negotiate an amendment into the ICC statute. And I'm looking at our two hosts, of course. And I would love to continue consulting with you and taking any advice that you have to offer on that. But I think, of course, in terms of the first of all, absolutely support Christina's point. And I think coordination is fantastic, definitely be more. And I think this event actually is extremely useful in that, and I'm delighted that IPI, as I understand it, will continue to explore all of these avenues and then act as some kind of coordinating body, perhaps, for some of them. But specifically the ecocide efforts, and the interesting thing, of course, is watching what's happening at national politically. The Stop Ecocide movement, which is just a private foundation, convened the panel at the request of Swedish parliamentarians, so not really a state-driven initiative, but is really a grassroots campaigning with membership all over the world and branches all over the world. And some of those, there's lots of very actively engaged people, and they're linked in with Extinction Rebellion and Fridays for the Future, really important youth movements, as well as with politicians. And I think we probably all saw that the Belgian Parliament last week passed a resolution that Belgium should support the incorporation of ecocide into the Rome Statute, for example. So while the work at a sort of a diplomatic and state representative level, the work at a grassroots political home society level, I think, especially around issues of the environment, is going to drive some of this forward.
No, thank you. Patricia, do you have any reaction to
Yes,
what has been
sure.
said?
Sure. I mean, I think the first point, I think here I'm in a slightly different position than others, although I'm, as I said it from the beginning, I'm speaking on a personal capacity and not engaging the Commission or the other co-chairs or members of the study group. I think for us, it's not really an issue of coordination per se, but it's we of course we're paying a lot of attention to what's happening with these other initiatives, and of course for us. It's because we look at state practice and we look at the relevant developments also within international organizations and other key stakeholders. For us, all these developments are very interesting to follow. So I would put it more, not so much as a question of coordination, but exchange of views and of course, from the point of view of the Commission following with a lot of attention and interest what's happening, and I think our mission, because of our role, for us, we look at this as a legal exercise. I mean, to come back to your initial point, we'll look at this, of course, as a legal exercise that then it's put at the service of member states. That's the role of the Commission for the broader political picture, of course. But for us, it is a legal exercise, and it's something that is done also in that perspective. So I just wanted to say that.
Thank you, Patricia. Christian, you asked for the floor, please.
Thanks a lot, and thanks to everybody who has spoken. I would have a lot of questions, I think, but just a couple of things that came to mind, and maybe go a bit deeper on the issue of coordination. I think it's particularly interesting with respect to the two advisory opinions, isn't it? And you both have emphasized that the main challenge is to get the question right. So would you be talking, would the two initiatives be, talking to each other as far as framing the questions and making sure, do you want that to be complementary or not? And I think, the ICJ opinion is clearly the one that would be an extremely prominent legal opinion. It's also one that we've been talking about for a long time, and it seems to be very difficult to get the question right. And you made it very clear that the ITLOS advisory opinion is easier to get, so to speak. So it's less of a political obstacle to overcome, because I think the advisory opinion in the GA will be relatively difficult. And to question to you, Kate, you touched briefly on the issue of territoriality, which I think I find very fascinating with respect to this crime. And I guess you can go very radical in two directions. You can say, the crime is committed where the damage is done in a particular country. You could also even argue, the crime is committed where the damage is felt, which is everywhere. So I'm sure, that's, I think, in the hypothetical in a way a little bit, but can you elaborate just a little bit more about where that is? And I think that would certainly be a very crucial aspect of conversation. And maybe finally, I think there is a bit of a contradiction in terms, in a way, between saying there's a sense of urgency and then legal action, because legal action is just not fast. And I think the most prominent court ruling for now is probably the Dutch court ruling on Shell, which, as far as I understand, is under appeal, but also may lead. It's a bit of a devil's advocate question. What if the consequence is that Shell just decides to dislocate? They're just like, okay, it's too difficult in the Netherlands, so we go. I don't know. We go to another place. Is that a good outcome as far as legal action?
Okay, 3 questions. Ambassador Levy, do you want to start off, and then we'll run across the panel?
Well, thank you. I think I will answer the question on the questions, framing the right questions. I think, we have in mind the questions that we're trying to put forward. But I think what's important, like you mentioned about the coordination and collaboration, I think it's important to work with a team that is handling the ITLOS question. So I think that's very important for us to work together. And I've already talked to the ambassadors who are involved in it, some of them, not all. So I think we are just starting, but going forward, we have to work together and exchange views.
Christina?
Yes, on the issue of exchanging views, I certainly agree. And to be clear, my colleagues and I, my firm and I, are not involved in the Antigua Tuvalu initiative. We were involved in developing the idea of the possible advisory opinion back in 2018, 2019, but it's since been taken forward. But we've been approached by a number of states who are inquiring as to both initiatives and whether they should be involved in one or the other. So I think that underscores the need to communicate between like-minded states to decide, will there be one approach? Will there be two approaches? If so, what question or questions will be posed? I think the importance of that is really underscored through my personal experience of the conversations that I've had with a number of states. And on the question of domestic and regional litigation, I think there's a real benefit for the reasons I stated earlier on this idea of cross-fertilization. So perhaps, I don't know, there could be commercial motivations for Shell wanting to remain and modifying its behavior in the Netherlands, but the decision in the Netherlands can influence litigation strategies taken by other interested parties in different states, and that can build momentum, build precedent that can be referred to by other domestic courts and by regional and international courts, and looked at and studied in developing, determining what the principles and how they are evolving.
Okay. Good. Kate, would you like to respond to any of the three or all of the three of the points Christian raised?
Well, I think especially the point about jurisdiction, I mean, that's exactly what I was alluding to earlier. I think it's really fascinating. I mean, first of all, we could think about universal jurisdiction, of course, and that might be included, at state level and for member states of the ICC, and then that possibilities where the problem is lack of political will to act in an enforcement capacity. But then we can actually think about the legal theory of where the crime occurs. And exactly as you said, Christian, I mean, where's that going to be? Where the decision is taken? If we think about a multinational corporation, perhaps, where the decision is taken, where a certain element of the action is carried out, a different element of the action, or again, where the effects are felt. And I'm not aware of any jurisprudence at the ICC which has already explicitly looked at that effects, Lotus approach to crime, but it certainly would be a possibility. And I think could open up all sorts of very interesting accountability options where there currently are none. So it might be a little sort of time bomb hidden in there.
Yeah. Patricia, we turn to you. Any reflections on what Christian said?
I'll make a small comment on the issue of whether legal action timings are compatible with the sense of urgency. And I think that in this case, we do still have a little bit, but not for that long, the advantage of time. I think the efforts that we're seeing here now are very different than in other cases where, as I mentioned before, international law was completely reactive. I normally say as a joke to my students that international law is normally always one war late, and now it's one pandemic late. And I hope it's not fully one climate change crisis late. And I think we are, since I'm in the UN Framework Convention and then the Paris Agreement and now these initiatives, we are in a moment where the science is clear in the sense that we are going on the wrong direction, but the full-scale effects are not there yet. And I think these different initiatives, they are showing that we are trying to do, although the legal timings are slow, we know they are slow. If you think about international courts and tribunals, but also the International Law Commission, although in this case, I think we are working in a relatively speedy pace compared to other topics. But I think that here we do have the advantage, but we have to be quick to try to have the legal tools not to solve the problem. I once had a student when I was discussing the issue of sea level rise, asking, why don't you outlaw sea level rise? And of course, that would be very interesting, but this is not the possibility. But putting together the tools so that the impacts are less severe and they are also less unfair to states. And so I think here we still have a little bit of time, but we have to move quickly, at least to have a robust legal framework to help states coping with climate change.
Yes, and on this point, Patricia, to join you and Christian, for me, at COP26, it was extraordinary how the energy that existed in the streets, the sense of urgency, the passion for these issues dissipated very quickly to the point that in the negotiating room, there was no sense of urgency whatsoever. It was a straightforward technical exercise, no human dimension to it. We all became technical experts and nothing beyond that, which was for me rather remarkable, because only a few meters away, we had representatives of indigenous persons, we had youth representatives, they were taking the floor in plenary. The Secretary General said, you know, this is, we're at a desperate juncture, but that didn't exist in the technical exercise of drafting a particular paragraph or two or three that basically led us to develop an agreement. The other thing that was most remarkable was that we, on one critical issue, reached an agreement at a technical level, but at the ministerial level, it completely fell apart. The opposite of what was intended for the COP, which was that the ministers would provide the glue to bind all of us together. And it had the opposite effect on one key provision. So how do we prevent that in one way? How do we prevent the normal way in which we negotiate all the other issues from infecting the method by which we approach these issues? And we saw, as Christian said, in the discussions in the Security Council, they were quite lengthy over the last few months. And in the end, it fell apart. So the maneuvering of these questions has to be done extremely carefully, as Kate sort of pointed out. And what I hope we can do, maybe this is not so much a question, but what we can do in the next 6 months in IPI, together with Liechtenstein, I think we'd be ready to do this, is hold closed workshops on each initiative to better understand the dimensions, consequences, what we do afterwards, how we lay the stage for future action, and then interrogate them in greater detail. And Kate, on your proposed definition, there are all sorts of other initiatives that could be possibly brought into being, because you need to also think of Article 17, the complementarity provisions, and look at what already exists, either in domestic law or as initiatives that may come online. For instance, conveying personhood rights to flora and fauna. And there's one initiative that the country that I come from put forward publicly about using the IUCN Red List as a trigger for the exercise of domestic jurisdiction when a particular species is endangered. But we move then from the right to life to the right to exist as a species. And that discussion fits between all of these, because the connection between biodiversity, of course, and the loss of biodiversity with climate action, climate change, and then the effects it has on what we need to do in climate action is quite pronounced. So a mush of ideas that just came out, or comments. I'm not sure it's entirely intelligible, but if any of you would like to react before we close out the discussion, I'd be happy to elaborate on the Jordanian proposal some more if you would like as well. Yeah, Kate?
I would just say that I mean, absolutely, I agree, and I entered into this project very much. We have a working group at UCLA Law, actually, which is about looking at international criminal law and the protection of the environment more broadly. And I'm absolutely fascinated in the rights of nature movement and in the interconnectedness. And we've tried to use sort of words in the definition that might allow these ideas to somehow speak. But I think something like the crime of ecocide is, I mean, even the name, which I was initially hesitant about myself, actually, but I now understand the power of it, because you can speak to absolutely anybody. And I say, oh, I'm interested in, or I'm working on, or I'm campaigning around a crime of ecocide, and people understand immediately what I'm talking about. And also the reaction, oh yeah, that makes sense. Doesn't that already exist? Well, yeah, that should totally exist. And I do think that it's such a simple context, such a simple concept. And it speaks to people so directly that I think something like that could be a really important trigger for these other processes. I mean, it could be one of these little steps that people can coalesce around, and it might give some additional impetus towards all of these other issues. I mean, that's how I've seen it working. We've been really surprised at the way it's been taken up and how positively it's been taken up by people sort of in general, by the public in general, or also by politicians who think that it sounds like a statement of what we're aiming for. You know, it sort of sums up the point. We cannot destroy the planet. Destroying our environment is on a par with, you know, destroying a human group. We can't do it. It's all of us. It's got to stop. So I think it has a, you know, potential to galvanize action.
Is there not a danger, though, and it's the obvious question, and perhaps Christian mentioned it right at the beginning, that we seek the cooperation, if we ever to come to terms with the rate at which climate change is taking place, of those who may very well feel threatened by what it is that we're doing. In other words, or what the initiatives are pursuing. In other words, there's a sort of element of self-incrimination or self-indictment if these were to lead to some sort of instrument that is effective in the end, right? Unless you bracket the temporal jurisdiction part very carefully, how do you get the buy-in of the very states, many of whom will feel threatened by just the discussion on this, on ecocide?
Yeah, I mean, of course, that's a brilliant point and absolutely crucial. I think we have to get to the point where a state, you know, would not feel comfortable opposing it, maybe for domestic political reasons, or maybe for, you know, international issues of international presentation and prestige. I think that's the power of the word. It's quite a hard idea to oppose. I mean, ways will be found, of course, but I mean, I think that's the only way I can see that really working. I mean, it has to become something that no state feels comfortable arguing against.
Well, thank you, Kate. Before we close out, could I turn to Christian for some final reflections, and then I will suspend the meeting.
Thank you, Zeid. Look, great discussion. Really grateful to everybody here. I think you know, we want to look ahead with you. So clearly we've, you know, touched the surface of all these initiatives that have all been very well thought through. So a lot of time has gone into them, and I think it's time that we should also invest here. So we will be looking with you to have, as you said, you know, with the time frame indicated within the next semester, first half of 2022, as a more in-depth discussion on each of these strands. You know, one area that maybe merits a bit deeper discussion that was not, you know, was mentioned today is simply, you know, what's going on in national courts. There is a lot of legal action in European courts and otherwise, and maybe we can bring in some practitioners on that. So, you know, I think as far as we are concerned in the area of international law, probably the most pertinent discussion right now. So extremely happy to be part of this in the next few months with you and everybody here. Thank you.
Thank you, Christian, and thank you, Ambassador Tevi. Thank you, Christina. Thank you, Kate. Thank you, Patricia. Ladies and gentlemen, we have reached the end of our time. We hope this, as Ambassador Benavente was made it clear, is the start of a series of discussions that we will be hosting in due course. Thank you for your attention. We bid you a happy holidays wherever you are in the world, and we hope everyone is deserving of some rest. We hope that you will enjoy it too. Thank you so much. All the best to you all. Bye-bye.